Hello, I'm Helen Good of the Elizabethan Star Chamber Project, and I'm here again with some of the wonderful readers from the Beyond Shakespeare Company who've kindly agreed to read some more cases for us. Now, we're looking today at cases brought to Star Chamber by the Queen's Almoner, who was always a bishop. When the Queen gave charitable alms to a person or an institution, the Almoner provided the cash from his fund. I don't know how it worked, although no doubt somebody else will know. I imagine that the money was held in the royal household rather than in the exchequer of receipt, and that the main sources of funds for the Queen's charity were quite possibly the estates forfeited by suicides, fellow de se, felons of themselves, and diadans, the instruments of accidental death. Now, if the Almoner had trouble in collecting, he would use Star Chamber for enforcement. So I must first introduce our readers from the Beyond Shakespeare Company. The first is reader number 1.
Hello, I'm Greg, and I'm currently situated quite near Stratford-on-Avon.
And reader number 2 is
Lynsey Beauchamp, actor from Scotland.
Reader number 3.
Hello, I'm Tom from Brighton.
And reader number 4 is
Rachael, actor, on the case.
Okay, thank you. We'll start with fellow de se, felony suicide. All convicted felons forfeited all their estates to the Crown, but the estates of suicides went to the Queen's Almoner. Now, as an example, I've just collected up a notice, a fragment of some of the cases which we have identified as suicide on the project from the London area, and here they are. The first is the Queen's Almoner, and Jewel and Shorter, and this is from the interrogatories.
Item: whether did you know one Joan Powell, who had a certain dwelling in the Old Bailey in London, and whether did you hear that she was a felon of herself, yea or no?
Item: did you know one Henry Blewett of the Temple, gent, and one Thomas Blewett, his brother, yea or no?
Item: whether do you know or have you heard what money the said Joan Powell delivered or caused to be delivered as her own money unto the same Henry Blewett, not long before her death, to be kept to her use, and what is your perfect knowledge therein?
Okay, so here we have Joan Powell, obviously either a widow or a single woman, who owned property in the Old Bailey in London, but some of her money was being held or may have been held by the Blewetts. And obviously once she was declared a suicide, that money would quietly disappear. Or so the Queen's Almoner believes. The next one is the Queen's Almoner against Lamar.
Whereas one Peter von Bellows, late of London broker, became fellow de se, and also one David Lemaire, a merchant stranger dwelling within the city of London, was indebted unto Peter von Bellows, the following interrogatories are to be ministered to David Lemaire, merchant stranger of London, in the matter of debts due to Peter von Bellows, fellow de se, a factor or broker of London.
So here we've got all sorts of problems for the Almoner. None of these people are English. They are merchants. They have no doubt very complicated affairs. And it's a question of just how much the almoner can manage to extract. The next one is the Queen's Almoner and Robinson.
Interrogatories to be ministered to John Robinson, Arthur Robinson, Henry Robinson, William Robinson, London merchants in the matter of the goods of Thomas Lawrence deceased, who killed himself, fellow de Say.
And the Queen's Almoner and Westcott.
Joan Bradbury, late of the parish of St Clement, nigh Candlewick Street in London, hanged herself in a house, fellow de Say.
The Queen's Almoner and Chamberlain.
Lewis Dianard of St Martin's in the Field, Co. Middlesex, a stranger born, killed himself, fellow de Say.
And the last is 3 separate cases for one suicide. It's the Queen's Almoner and Johnson, the Queen's Almoner and Cooper, and the Queen's Almoner and Style.
One Thomas Wright, late of Somerset House in the Strand, in Middlesex, gentleman killed himself and became fellow de Say.
Okay. Can I ask, is this becoming clear?
Yes.
Rachael.
Yeah, the merchants that came up and these people, who are the merchant strangers, that they don't live in the UK. I'm assuming they don't live in the UK, or at least not in London. So my question is like, in modern day, whether somebody's a citizen, like if I was a US citizen and committed a crime in the UK, that I would stand trial in the UK and not in the US, even though I'm a US citizen. Would it be the same thing back then, that somebody of another country would be charged with a crime if they did it in the US, or not in the US, in the UK, and not sent back to their country to stand some legal whatever?
Yes, if we're talking about crimes, certainly the place where the crime was committed is the place that has the jurisdiction. So whatever your nationality, if you commit a crime in London, it's the London courts before which you will be brought. These actually are merchants living in London, but they are merchant strangers in that they're not English. This is before 1706, so there's no United Kingdom. We're all English. We can forget the rest of them. They're foreigners. But so if the English law will apply to them wherever they are. There was no extradition at this time, but there were a couple of cases of, they call it rendition, don't they? When you go and kidnap someone in a foreign country to bring them before your own courts. Extraordinary rendition, that's right. There were a couple of cases of that. Now, any more questions? Any more? Rachael.
Because they're also referring to people as strangers here. So I'm assuming that means, like foreigner, just not born there. What was the path to naturalization, if there was any? And like, what was the, I guess, legality surrounding how people, how there's green cards and things like that, like, or visas?
Yes, you could get, I think they were called letters of denization or some similar word. You could get permission to remain and to carry on your business. to become naturalized took a private act of parliament. Not many people did it, really. It was regarded as somewhat strange. But if you were born here, you were born within the country, and you were born a natural subject. This caused problems for some people who got born abroad accidentally, so that their mother failed to get back to Yorkshire in time for them to become a Yorkshire cricketer or whatever. But and there are private acts of parliament to restore people to their citizenship. It was an expensive business, but they tended to go through on the nod, I think, provided all the right people had been paid. Are we ready to go ahead? Yeah? Okay, yes. Now, here is a case of drowning. It's in the Humber estuary to the west of Hull, but it probably is in Hull Shire, because Hull was a county all of its very own at that time. So here we are, the Queen's Almoner and Robert Spencer and Anthony Burnsell.
To the Queen's most excellent Majesty, humbly complaining, sheweth and informeth to and for your Majesty's humble subject, Anthony Watson, by the divine providence, Bishop of Chichester, your Majesty's Almoner. That whereas one Robert Atkinson, later Ferriby in Hullshire, in the county of York, being possessed in his lifetime, and at the time of his death, of divers goods and chattels, as his own proper goods and chattels to the value of 100 marks or thereabouts, and being possessed and interested in the said goods and chattels as his own proper goods and chattels in or about the month of August, in the 41st year of your most prosperous reign, did wilfully and feloniously, not having the fear of God before his eyes, drowned and destroyed himself, and so became fellow de se, by reason whereof of all his said goods and chattels, both real and personal, remain forfeited to your Majesty as belonging to your Majesty's prerogative royal, and and ought to have been at the disposition of your Majesty said Almoner, by virtue of your Majesty's letters patents under the Great Seal of England, for and towards the relief of your Majesty's gracious arms in that behalf, granted and made as per the said letters patents at large may appear. But so it is. May it please your most excellent Majesty that one Robert Spencer, then Mayor of the town of Hull in the said county of York, and one Anthony Burnsell, then Sheriff of the said town of Hull, did seize, take, and convert to their own use, behoof, and benefit all the said goods and chattels being of the value aforesaid, and the same and every part and parcel thereof do retain and keep from your Majesty's said Almoner, and have denied and refused, and still do deny and refuse, contrary to law, equity, and any good conscience, either to deliver the same to your Majesty's said Almoner, or to make such satisfaction for all and every the same as your Majesty said Almoner, in respect of your Majesty's arms, might in any reasonable sort rest satisfied. I'm sorry, I thought I'd read a sentence twice then. All which, and either of their doings and dealings tend manifestly to the breach of your Majesty's laws, and the dishonorizing of your Majesty's right to the same, and to the evil example of such like offenders, if true due reformation were not had and provided in these and the like cases. And for that your Majesty's said Almoner is by the course of the common laws of this realm remedies for the recovery of all and every the same. May it therefore please your excellent Majesty, the premises considered, to grant your Majesty's writs of subpoena to be directed to the said Robert Spencer and Anthony Burnsell, commanding them and either of them by virtue thereof to be and appear before the Lords of your most honourable Privy Council in your Majesty's High Court of Star Chamber, to answer all and every the premises, and to abide by such order for the same as the said Lords upon the hearing of the case shall determine and set down. And your majesty's said subject in Almoner will daily pray, as he is most bounden, for your majesty's precious health, long to continue over all your faithful and loving subjects.
Wow, that was a tremendous pace.
Does he believe in full stops, this guy?
Of course he doesn't believe in full stops, but I should have gone through and put in a few commas for you.
It's all right, don't worry, it was just funny.
Yes, in fact, I mean, these things do divide up. First of all, it says who everybody is. And then there's the usual clause which begins, but so it is, may it please your most excellent majesty. And then says how frightful it would be if this was allowed to continue. And then asks, may it therefore please your excellent majesty to grant your writs of subpoena. And so to haul these people before the court and hand out punishments. Now, in fact, this is where we find out why local historians are so important for Star Chamber. I mean, firstly, I can tell you he's gotten the wrong way round. Spencer was the sheriff and Burnsell was the mayor, but it doesn't really matter. From Star Chamber records, we have absolutely no idea what happens to the case. All there is this lonely bill of informational complaint. But as it happens, I am also a local historian for Elizabethan Hull. And so I can tell you a little bit more about what's going on. And Lynsey is now going to read from the Hull Bench Book, which is the corporation record. Okay, Lynsey.
Hull Bench Book 4, folio 335. The 24th day of November, in the 43rd year of the Queen's reign, in the year of our Lord 1600, and in the time of the mayoralty of Hugh Airman. The said Mr. Mayor, upon the day and year aforesaid, with the full and whole consent and assent of William G., Luke Threscross, John Lister, John Greaves, Anthony Burnsell, and Marmaduke Haddlesey, alderman of the said town of Kingston upon Hull, did ordain, agree, determine, and set down to try the right and claim which they have unto certain goods and chattels, which of late belonged unto one Robert Atkinson of Ferriby, in the county of the town of Kingston upon Hull, yeoman, who was found by inquisition, had and taken for her majesty to be fellow de se within the county of York, with and against Robert Redhead, who pretendeth to have right and claim to the said goods. In consideration whereof, Anthony Burnsell, then mayor of the said town of Kingston upon Hull, and Robert Spencer, sheriff of the said town and county thereof, did upon the day and year above said desist from their claim and demand unto the said goods, and yielded all their title and interest to the mayor and burgesses of this said town. Okay,
now then, this seems more complicated than it is. What's happened is that the town, in the person of the sheriff, has got control of the property, but they're under attack from this man, Robert Redhead. Now, at this point, we haven't a clue who Robert Redhead is. But what the sheriff and the mayor have done is that they have surrendered their claim to the town. The corporate name of the town is the Mayor and Burgesses of Kingston upon Hull. So instead of it being a personal claim, a personal responsibility of two people who happen to hold offices. The town itself is taking over the case. This is not a surrender. This is limbering up for a serious battle. Rachel.
Or Tom.
No, I think you.
No, it's me.
No, but, no. If
Hull.
the town. This is my question. If it's the town of Hull that takes it, you know, and they're taking in the name of the crown, you know, the money from the fellow de se, do any of these incorporated, you know, towns get a part of that, or does it just go directly to Elizabeth or the monarch?
It goes to the crown, but they've got their hands on it. Tom.
Oh no, forgive me. I thought we were just following on. I'm reader 3, so.
Oh no, sorry. We're in conversation mode here.
Right.
Rachel obviously had a question. Is everybody else on board? Okay.
Yes, please.
Well, I reckon if you're on board, then we can hope our listeners will be. Okay, so we move on to Tom with the next bit of the bench book.
Hull Bench Book 4, folio 341. Whereas heretofore, in the time of Mr. Anthony Burnsall, Mayor, one Robert Atkinson of North Ferriby became felon of himself, in that he drowned himself in the Humber, as by inquiry of the coroner's quest, holden a little from the Borough Haven within the county of York. It was found and given, in which Atkinson died, possessed of goods and chattels to the value of £60 or of thereabouts, whereupon the then mayor and sheriff, laying claim to the said goods, made entry accordingly. Likewise, Robert Redhead, in the right of the Lord High Admiral of England, pretended title to the said goods, and commenced suit against the said mayor and sheriff, whereupon, by the advice of the mayor and the most part of his brethren aldermen, and for the saving of further expenses and charges in suit, and for the quietness and sake, and for the friendship of the said Lord Admiral, there was given to Robert Redhead, Vice Admiral, for the time being the sum of £30, whereupon that suit ceased, and an acquiescence sealed by the said Redhead accordingly, and delivered to the use of the said mayor and burgesses.
Okay, they've bought him off. We now know who Redhead is. They probably didn't need to say it before, because they presumed that everybody who was reading the records would actually know who he was. He was a vice admiral. The background to this story is that the mayor of Hull was, by the Hull Charter, Admiral of the Humber. This did not mean that he wore a cocked hat and went up and down in a boat. It meant that he had the fees of all admiralty cases held in the north half of the Humber. So every time there was a new Lord Admiral, there was most tremendous row about how far the mayor was allowed to try cases and get fees, and how far the Admiral had to do it. The Lord Admiral could do it. And every time money passed and there was a composition made. But here, the Humber is an arm of the sea. It isn't a river, it's an estuary. So Redhead has come along and said, hang on, he died in the sea, admiralty forfeiture. Give me all the money. And Hull are saying, no, 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 no. he died, the body came ashore in Helsby, which is definitely in Hullshire. He died here, we take the money. And so in order to settle it, they give him £30 to go away and to cease his suit. And having got his £30, he then gives them a signed affidavit saying, an acquittance saying, won't trouble you again about this matter. This is all about money. Also about precedent. Rachael.
Yeah, so the acquittance that he gives them, so if somebody's family, like if one of their family members was like, say the father or the person who had the money of the house was a fellow décès, or the courts claim they were a fellow décès, could they sue for acquittance in the courts so that their properties or their money would not be forfeited to the crown?
They could substitute money for property, yes, but there's the family has no rights. They are often looked after to an extent in that they're not left completely destitute. But felony forfeiture was a big source of income for the crown, or in this case, a decreasing set of source of income for Hull, because they've lost £30 of it to the Vice Admiral. Okay, are we all right to move on? Nobody waving at me, goody goody. Okay, so we've got reader number 4, which is Rachael, yes? Yeah, and off you go.
Whole Bench Book 4, Folio 341. At the beginning of Hilary, term Anno 1601, in the time of the Right Worshipful Marmaduke Helsby, Mayor of the Reverend Father in God, Anthony Watson, by the providence of God, Bishop of Chichester and Almoner, to Her Majesty in the right of his office, commenced suit against the aforenamed Mayor and Sheriff, viz. Mr. Anthony Burnsell and Mr. Robert Spencer in Her Majesty's High Court of Star Chamber. Whereupon, as before, by the consent of the said Mr. Marmaduke Helsby, Mayor, and the most part of the aldermen brethren, and for avoiding further trouble, expenses, and for avoiding further trouble, expenses, and charges and suits, the sum of £15 was yielded to be paid to the said Lord Bishop of Chichester, Almoner, to Her Majesty, or to his deputy. Whereupon an acquittance was granted, dated at Hull the 25th March 1601.
Okay, so normally in England we say Chichester, but it doesn't really matter. Now then, so what amuses, this is our bill of complaint that Greg read earlier, that out of the blue, a year and a half later, because it takes the Almoner some time to catch up with all these suicides, they get this sudden, out of the blue, or maybe not out of the blue, summons to Star Chamber to show cause. And they undoubtedly put a man on a horse up to London, or else possibly the Almoner had a junior clerk in Yorkshire, and they came to an agreement. Now they'd had to give the Admiral 30 quid. But with the Almoner, they got away with 15. Now, I mean, this is just not apparent anywhere that these sort of negotiations are going on. But I'm willing to bet that behind every Star Chamber case concerning the Almoner and fellow décès, there are some little negotiations. And this is why most of the Almoner cases just disappear without trace. There's a bill, there's possibly an answer, and then they just disappear because I'm sure they're settled out of court. Money passes. But on the other hand, it's an interesting sidelight on how the early modern world worked. Please say yes.
Well,
Okay.
It seems to be rich pickings, where
Yes.
where every institution would have people keeping an eye on the records and going, quick, get in there, cause trouble. It's a good revenue stream for any organization.
Yes. Also, I mean, ordinary felony forfeiture for, you know, murder or whatever. If there was a big, if the person accused was a person of wealth, then the agents for felony forfeiture would be bidding to own the felony forfeiture before the trial started, because the collection was privatized. Lynsey.
Have you had an accident in the last 6 months which was not your fault?
Yep. Oh yes, yes. They were very well. They were lurking around. It's more who you knew. You know, well, I was at school with him. He's in charge of the felony forfeiture for this trial. I may be able to buy it off him fairly cheaply. You see, when you don't have a decent civil service, and none of the fine collection can be enforced except by selling it to someone who will go and terrorize people. Different world, very different world. But has its moments. Okay, now then we're going to have, yes, this is an earlier felony forfeiture. It's from Dunstable. We know where this is, I think. Bedford, yes, it's from Bedfordshire. And we've got a couple of answers to it, which makes it rather interesting. So I'll let Greg go with, it's your turn, isn't it, Greg?
It is, yes.
Jolly good.
Queen's most excellent majesty, in most humble wise showeth and complaineth unto your highness, your faithful and obedient subject, Edmund Freak, Bishop of Rochester, High Almoner unto your majesty, that where one James Cowper, late of Dunstable in the county of Bedford, the 8th day of September, in the 16th year of your most gracious reign, at Dunstable aforesaid feloniously, as a felon of himself, in a certain well at Dunstable aforesaid did drown himself, as an inquisition taken at Dunstable aforesaid before Richard Sampson, gentleman, one of the coroners in the said county, upon the sight of the body of the said James, by the oaths of 12 men, appearing to your majesty's laws of your realm, more at large it doth and may appear, by reason whereof all such goods, chattels, and debts, as the said James or any other to his use had and was possessed of the day of his said death, do belong and appertain unto your highness, and so to the only order and distribution of your said Almoner, in augmentation of your most gracious alms, by force of your most gracious letters, patents unto him in that behalf granted and made, as by the same letters patents, more at large it doth and may appear. And where they and where the said James, the day of his said death, was possessed of certain sums of money and certain specialities, that is to say, obligations of debt, and a shop book wherein certain persons were severally indebted unto the said James for the payment of certain several small sums of money, and of other goods and chattels, and of certain implements of household, that is to say, napery, bedding, brass, pewter, and other goods, amounting to the value of £200 or thereabouts, the very certainty whereof unto your said almoner are unknown. So it is, most gracious sovereign lady, that Marjorie Cowper of Dunstable in the said county, widow, late wife of the said James, and William Cowper the younger, his son, immediately after the death of the said James, came into the house of the same James, and craftily got into their possessions all such sums of money, and other things as the said James was possessed of, and the same have, and do convert unto their own proper uses and commodities, without having any right or title thereunto. And although your said almoner by William Otley, his attorney and deputy in the same county, have divers and sundry times inquired and instantly desired the said Marjorie and William the younger, and either of them to deliver unto him to the use above said all the said sums of money, specialities, and other things amounting to the said sum or thereabouts. But that to do, the said Marjorie and William, and either one of them, hath hitherto refused and denied, and not done not only in a contempt of your most gracious letters patents in that behalf unto your said almoner, granted and made, as is aforesaid, but also to the let and hindrance of your most gracious alms, which should have been ministered by your said almoner unto your poor and impotent subjects, and to the perilous and evil example of such like offenders, if condign punishment and speedy remedy by your majesty be not shortly and had and provided for in this behalf. In consideration whereof, may it please your majesty to grant your most gracious writ of subpoena to be directed unto the said Marjorie and William the younger, and to every one of them commanding them, and every one of them by the same personally, to appear before your majesty and the lords of your most honourable council, your most honourable court of the Star Chamber at Westminster, at a certain day and upon a certain pain therein, to be limited and then and there to answer to the premises. And your said almoner, according to his most bounden duty, shall daily pray to Almighty God for the prosperous estate of your majesty, and most high honour and felicity long to reign over us.
Okay, shall we, is everybody on top of that? Yep, good. Let's go straight into the answer.
The answer of William Cooper the Younger to the Bill of Complainant of Edmund Freake, Bishop of Rochester and High Almoner to the Queen's Majesty, Complainant. The said defendant saith that the Bill of Complainant now in this honourable court exhibited is only as he thinketh of malice towards him, wrought by some sinister friend of his unto the said High Almoner, to the end to put the said defendant to charges to his impoverishment, and the matters therein contained, devised and imagined. For he saith that, true it is that the said defendant before this time had declared and showed the truth in the matters in this bill, exhibited to the said High Almoner, being thereupon by him before this examined, upon which his answer, this defendant was by him, the almoner, promised spare of trouble, and also spare for his appearance upon the like suit in this honourable court by him then exhibited. Nevertheless, the said almoner, being in charity and unmindful of his promise, enforceth the said defendant, being a very poor man, to his further charges, and to answer to the same matters against him in this court by the said almoner exhibited, whereunto already he hath answered fully. Yet notwithstanding, if by this honourable court he shall be enforced to answer, the advantage of the insufficiency of the said bill and the matters therein contained, to him always reserved, for answer he saith, that the said James Cooper, father to this defendant, in the said bill named, came to his sudden death, as he thinketh, according as in the said bill is specified, to the great grief and loss of the defendant, after whose death the said Richard Sampson, as coroner, inquired thereof by the oaths of 12 men, as also what goods and chattels with other such like the said James, his late father, or any other, to his use had, or were possessed of, at the time of his said death, as in the said bill is likewise contained. Which coroner, upon his discretion, called this defendant and others before him, whom he caused to take a corporal oath before him in the presence of the said 12 men, to answer to certain articles, then by him to this defendant exhibited, concerning his knowledge of such goods and debts as were his father's at the time of his death, who then to his knowledge truly advertised the said coroner and jury. Upon which information the jury, as he hath heard, found divers goods of his said father's to the value of £7 or £8, as he hath had understanding. And of any other his goods, since the same inquisition found, he hath faithfully advertised William Ottey, attorney to the said complainant thereof, from time to time, hoping that his good will therein would have been recompensed with some other favour than now is showed, and the charitable devotion by the said almoner of some of those goods of his said father's towards the release of him and his great charge of children. Without that the said William Cooper, together with Marjorie his mother-in-law, or otherwise by himself alone, did enter immediately after the death of the said James his father, and did take or carry away any money, napery, or bedding, or other his goods whatsoever, other than such as he, the said defendant, hath truly advertised the said coroner, this complainant, or William Ottey, his attorney. All which the said defendant is ready to aver and prove, as this honourable court shall require, and prayeth to be dismissed with his reasonable costs and charges in this behalf sustained, as to this honourable court shall seem good.
Okay. I think we need to sort out what a mother-in-law is, because it's not what you're probably thinking it is. It means here stepmother. In law, she's his mother. I've never seen stepmother. I mean, stepdame, yes, occasionally. Stepmother is much less usual. Mother-in-law is used for both what we would call a mother-in-law and a stepmother. All it means is that by law, she's his mother. But we're talking about a second wife. Who the great charge of children, whether James is talking about the great charge of children being his children, or whether he is now responsible for all his younger siblings, I don't know. A local historian would be able to fill you in on this probably, but I can't.
Yes, it's not clear, is it? There's William Cooper, then there's his father James Cooper, Marjorie, who you've now mentioned is in fact the second wife, so the stepmother.
Or third or fourth, we don't know, but yes.
Whatever. So one could surmise that James, who had several wives, also may have had several children by each of these wives. So
yeah, all these children that, yes, it's William who's responsible for them, isn't it? Yeah. Rachel.
Yeah, my question, because that just, it's the density of the text that's just, I mean, it's a legal document, you know, but were they accusing somebody of going in and taking some goods before it came to trial to try and hide the, okay. Okay.
it wasn't unusual. Tom.
It puts it into perspective that it's a desperate act because of the consequences on your family. I know in Japan they have this what do they call it? A suicide where you jump in front of a train, but then your family has to pay the cleanup costs.
Yeah.
So you get back at your family, but these are people who have committed suicide and brought this terrible, horrendous, ruinous act upon their family.
Mm, mm, mm.
So it's very strange.
Well, I think suicide is always an aggressive act.
Mm.
I mean, you're always trying to say, well, I don't know. But yeah, suicide was fairly devastating for the family left behind. You could never say of your family, you'd be better off if I was dead, because that can never be the case. If you're the property, if you own the property of the family. But there's, I mean, poor old William, he's saying, I've done my best. I was honest with the coroner. I have, every time I found something, I didn't go in. Because what they're saying is that there were debts owing and he's taken the bonds and there was a shop book. What Cooper's occupation was, I don't know, but obviously he bought and sold. Maybe he created, but there was this shop book with the debts and it's disappeared. But to be honest, I mean, this is all very understandable. Rachael.
So were the debts owed to William Cooper, or was it the debts that William Cooper owed to others?
Oh, well, the debts he owed to others wouldn't be a problem because they would come out of the estate, but the debts owed to him would need to be chased by somebody.
Mm. So they would be valuable for people who wanted to, you know, collect money or collect debts. And then one more question. How you said they came out of the estate, are the persons left behind in the family, like if there were debts to be collected from the estate and the debts exceeded the price of the estate left behind, you know, in the estate in land or cattle or you know, pounds and things like that, would then the family be liable to make up the remainder of the debt, or does that get walked out?
No, the heir. I mean, the inheritance laws were a bit more fixed than they are now. I'm not sure whether you could repudiate your inheritance on the grounds that it was a minus number. I don't know, to be honest, how that would work, but certainly a number of families were paying off their father's debts quite late on, but that was presumably because they wanted to retain the family home. So in order to do so, they had to shoulder the debts. It's not a field in which I'm skilled. I'm just assuming things. Any more? Okay, and we have a second answer.
From the from the answer of Marjorie Cowper, widow. James Cowper, her late husband, did feloniously drown himself, and so it was found by the Inquisition in such a manner, and from as in the bill, the said bill is declared. And true it is that the said James was possessed of divers goods and chattels, money, debts, and other things at the time of his death, part thereof being in his own house when he died, and part thereof in other men's hands. Since which inquisition one William Cowper, the elder son of the said James, as next heir unto him, entered into the house late of the said James, and upon all goods, chattels, specialities, and household stuff in the same, and expelled and put this defendant from the same, and so keepeth her out still, and will not suffer her to have any part thereof, or take any of her own raiment out of the said house. And thereby she is compelled to borrow part of her raiment that she now weareth of others. And therefore this is a needless suit, unfit to be exhibited against her, who nothing have to the answer said complaint, nor to relieve herself, but it is holpen by her good neighbours and relieved by charity, whereof that this defendant hath any of the goods or chattels late of her husband, of her said husband, in her custody or in the custody of any other of her use, or that she either hath the shop book, specialities, or obligations mentioned in the said bill.
Okay, so here we have, this is what I love about Star Chamber. Suddenly you get a light into some little occurrence. And here we have Marjorie Cooper, wife of the late James Cooper, who is not enamored of her son, her stepson, I would say. Far from going into the house, she was thrown out of it. And he won't even allow her to go in and collect her clothes. Yeah. Now, these answers are given on oath. That doesn't necessarily mean they're true. But you can understand why I'm so fascinated by Star Chamber. I mean, it's a little light into these houses. She didn't get the bonds of obligation. She didn't get the shop book. She didn't get anything. She didn't even get her clothes.
It's like the Coronation Street of the day or something, you know. It's the sort of household or householders dramas.
Yeah. Yeah. Anyway, there you go. So that's that case. I don't know what happens next. I don't know who these people were, which is why I need a local historian from Dunstable who will know these names. When I go round to, used to before the pandemic, go round to local history societies. And the first half of the talk is all about Star Chamber. And the second half of the talk is just listing all the cases we found from that area. And what is amazing is that they know all the names and they don't know any of the cases. The cases are completely new to them, but they know who the people are. In fact, one of the people turned out to be an ancestor of the chairman of the local history society. So he got very excited. But no, it's local historians that I'm after to rush in and tell us what to do. The problem is that a lot of them can't read secretary hand, so they're dependent on other people. Now, most of the estates that we've been dealing with have been relatively small, but occasionally there is a massive estate to be claimed. And this one actually gets into the history books. And here we have some background from ODNB.
From Carol Levin's biography of Percy Henry, 8th Earl of Northumberland in the Oxford Dictionary of National Biography, Northumberland continued to dabble in treasonous plots surrounding Mary. He had several of his sons educated in Paris by Charles Paget. Paget was an accomplice of the conspirator Francis Throckmorton and visited Northumberland at Petworth in September 1583, perhaps hoping to make it the base for his invasion of England, but more probably trying to apprise his associates of the current situation, advising them not to support any plots. Certainly Northumberland was sympathetic to Mary, enjoying intrigue, and had a weakness for indiscreet comments. The government was convinced that he was seriously involved, and in December he was placed under house arrest for assisting Thomas Paget, 3rd Baron Paget, and Charles Arundel to escape to France and for speaking with Charles Paget. He was removed from his governorship and his stewardship. Northumberland was sent to the Tower on the 9th January 1584 for denying matters confirmed by witnesses. Sir Francis Walsingham was convinced that he was a Catholic. In June 1585, the government considered bringing charges of treason against Northumberland, but did not pursue it, although the reason why is unknown. He was found in bed in the Tower on the night of 20th to the 21st of June, dead from a shot through the heart inflicted with his own pistol, which was still in his hand. The Star Chamber inquest held on the 23rd of June determined that his death was suicide. He was buried on the same day in the chapel of St. Peter and Vincula in the Tower. Some Catholics, however, were convinced that Sir Christopher Hatton, the Vice Chamberlain, had the Earl murdered on the government's orders. A Latin pamphlet published at Cologne made this claim. It was soon translated into German, Italian, Spanish, and English. If Northumberland had been shot 3 times in the chest, as some affirmed, this would indeed seem to rule out suicide, but if not, suicide does seem much more probable. It protected his family from confiscations. The popular belief in Hatton's guilt, however, was strong. In a letter of 1601 to Sir Robert Cecil, Sir Walter Raleigh casually referred to Hatton as Northumberland's murderer. The declaration by the Crown after Northumberland's death stated that he conveyed Charles Paget and Arundel out of the country after Throckmorton's arrest because they were the only real witnesses against him. The Dowager Countess of Northumberland remarried shortly after the 5th of December, 1587, her second husband being Francis Fitton of Binfield and Berkshire, a kinsman of Northumberland who had long been her steward. She died on the 28th October, 1596, and was buried in Westminster Abbey.
Okay, now can we get over the fact that the lady married her steward, which we are allowed to notice on the grounds that we're not working for Beyond Shakespeare now. Right. We've got a local historian.
Not quite. I just know 2 of the places. I just
know 2 of the places.
I just popped the Throckmortons because they lived at. I'm going to get the wrong now. Coates Court or Bannister Clinton, which are near here, and I know Binfield very well. I was just suddenly places pop out at you in these things, and you think,
Yeah. No, I mean, it's a big, as you can imagine, the Earl of Northumberland had a lot of property. Now, what they're saying is, what the writer here is saying is that he killed himself in order to avoid felony forfeiture for treason. I don't think she has taken on board the fact that there was felony forfeiture for suicide. Now, it's not, however, as fierce as for treason. For treason, you would find that the entire family would suffer, and you would probably need for the heir to inherit the title would probably take an act of parliament. I mean, if it was properly done with a proper trial. So he does protect his family, but not his own property and that which should go to his heir. What actually happened to him, I really don't know, but you can see that it's one of those cases where everybody gets excited. Tom?
It smells fishy. He was buried the very next day, 3 shots in the chest, if there was indeed. But the speed of the burial was very suspicious, and yeah, it takes some skill to shoot yourself 3 times in the chest.
He was buried in consecrated ground, although a suicide. St. Peter ad Vincula is undoubtedly consecrated ground. So, you know, here you've got an Ophelia situation. Rachael.
Yeah, to what Tom said, I mean, like, to shoot yourself 3 times in the chest back then, like to have to reload the gun, the amount of time that would have, as you've already shot yourself in the chest once. It does sound like what the other guy referring to so-and-so as his murderer, it does make that seem sort of likely by that view of it.
I would say on the whole that the status of the pamphlets being published in Europe at the time would be about the same as, I don't know, something coming from the desk of Donald Trump. You know, I mean, about the same reliability. And so I think that's where the 3 shots comes from. I think that the letter could be very much a joke. Oh yeah, the man who shot Northumberland. I mean, if half of Europe is saying that Hatton shot Northumberland, I mean, it seems to me highly unlikely that Hatton wouldn't delegate the job to some. I mean, it's never the lords who strangle people in the tower. It's always, they always send in a couple of blokes who can be shot conveniently later. Or so we learn from the early modern dramatists. Yeah, I mean, I don't know, I wasn't there, but certainly I wouldn't put any particular weight behind a pamphlet printed in Europe at this time. Rachael.
No, I just put in the chat that it's like yellow journalism or something, or not good, not research, not necessarily true or whatever.
No, and highly political. I mean, we're talking here about 2 the Protestant world and the Catholic world. And Northumberland is being claimed as a martyr for the Catholic world. Because the Mary they're talking about is Mary, Queen of Scots, which I possibly should have made clear, but I rather assumed everybody would know. Sorry about that. Yeah, so the Earl's holdings were large and his financial affairs were incredibly complex. So Almoner cases are spread over a number of counties, but here are two typical ones from Northumberland, the Queen's Almoner and Home.
A bit of information was brought by the Queen's Almoner against Robert Helm, William Carr, Robert Bates, Isabel Bates, Mark Errington, William Fenwick, Cuthbert Bates, George Gray, Robert Helm, Thomas Bates, claiming that Robert Helm of Tynemouth in the county of Northumberland, yeoman, and Thomas Bates of Pruto in the county of Northumberland, gentlemen, were bound in £800 to the late Earl of Northumberland, and the said Earl was found to have killed himself, fellow de se, in Her Majesty's Tower of London. The deponents sworn and examined on the 8th of January in the 31st year of the Queen's reign were James Ogle, Esquire, and Edward Gray, Esquire.
Now, if we look at the time distance, that's the 31st year, January in the 31st year. So we're talking about 1589-ish. I undoubtedly get that wrong. He died in 85. So this is probably 5 years later. The Almoner is still desperately chasing down, in this case, probably £400, because the bond would be for double. What happened with the bond was you gave a bond for £800 to repay 400. It was a sort of double or quits thing. So if you failed to pay the 400 on the due date and didn't renegotiate a new date if you couldn't, then you owed 800. So this is probably for £400. And if we go on to do the next one.
Interrogatories were to be ministered to Mark Errington and William Fenwick to demand whether Thomas Bates of Pruto Castle in the county of Northumberland and Robert Helm of Teignmouth in the same county of Northumberland were bound to the late Earl of Northumberland in £160 for payment of £80, and whether had this been paid to the Earl of Northumberland before his death.
So you can see that what we've got here are one of these crazy situations where they're trying desperately to discover at what stage this transaction had been when the Earl died. Was the money still outstanding? Had it been repaid? Where's the receipt? Who's still got the paperwork? And as I say, there are this sort of small case all over the place. As the Almoner struggles to get in as much as possible, and everybody else struggles to conceal as much as possible. Yeah, a fun time. Now then, we're moving on to the next type of case that the Almoner brought. And this is called the deodand, originally deodandum, given to God. And it's something that had been the immediate cause of the death of a human being, was supposed to be given to God as an expiatory offering. And so, in my view, especially after the Reformation, it was forfeited to the crown to be applied to pious and alms-giving uses. Now, according to the OED, it was only abolished in 1846, which I think is quite amazing. Whether it was still being enforced in 1845, I don't know. But the object that causes a death is a deodand, and the almoner collects it, or more usually its value, to put into the fund. Right, now this is a Berkshire case, the Queen's Almoner and William Stevens.
To the Queen's most excellent Majesty, humbly complaining, showeth unto your Highness, your Majesty, humble and obedient subject Richard, by the province of the good Bishop of London, your Majesty's Almoner. That whereas one Edmund Bullock, late of Eton, in the parish of Appleford, in your Majesty's county of Berkshire, labourer about the 14th day of January in the 37th year of your Majesty's most prosperous reign, thatching a certain stack or rick of beans and peas, one of the staves of the ladder on which the said Edmund Bullock stood upon in the thatching, and said stack of rick did break, so that the said Edmund Bullock by misadventure fell from the top of the said ladder and rick upon a prong, which did stand by the hedge joining to the said stack or rick, and so to the next day following died of the said fall, and hurtled from the top of the said rick and ladder. By reason there wherefore the said stack or rick of beans and peas with the said ladder and prong, all the same being accidents to the death of the said Edmund Bullock, and being goods movable, being of the value of 20 nobles and upwards, are forfeited to your Majesties or as a deodand, and belonging to your Majesty's prerogative royal, and ought to be at the disposition of your Majesty's Almoner, by venture of your Majesty's gracious letters, patents unto your said subject and Almoner, in that behalf granted and made, as by the same letters, patents and large may be appear. But so it is, if it may please your most excellent Majesty, that one William Stevens of Eton, in the said parish of Appleford's husbandman, who did owe the said stack or rick of beans and peas, from the height whereof the said Edmund Bullock fell, which was the chief occasion of his said death, being of the value above said, doth withhold, deny, and keep the said stack and rick of beans and peas, and the ladder and the prong from your Majesty's said Almoner, and hath refused, and still doth refuse, to deliver all the same of your value thereof to your Majesty's said Almoner, who hath right to all the same by reason of the said Edmund Bullock, his death as foresaid. All which the said William Stephen, his doings in withholding the foresaid goods, contrary to the law, equity, and conscience, and denying to make satisfaction to your Majesty, said Almoner, according to the value of them. And in practicing by all substill and sinister means he can or maybe devise to defeat your Majesty's right to all the same, and your Majesty's said Almoner, from the disposition therefore thereof tend to the breach of your Majesty's laws, and to the evil example of such like evil disposed persons and lewd offenders in cognine and worthy punishment of the redress thereof were not provided in that behalf. May it therefore please your most excellent Majesty, the premises considered, to grant your most gracious writ of subpoena out of your Majesty's High Court of Star Chamber, to be directed to the said William Stevens, commanding him by venture thereof personally to be and appear before in your Majesty's Court of Star Chamber before the Lords of your Majesty's most honourable Privy Council at the certain day and under a certain pain by your Highness to be limited and appointed, then and there to answer all and every premise and to abide such order therein as the said Lords of your Majesty's Council shall upon the hearing of the case order and set down. And your Majesty's humble and loyal subject will daily pray as his most bounden for your prosperous estate of your Majesty's most royal person, long to reign and rule over us.
Thank you, Tom. Not an easy one, especially as I hadn't modernized it hardly at all. Sorry about that. Did everybody get the drift of what had happened?
Peas and beans stack.
Peas and beans in a stack. And he was thatching it, the stack, presumably to keep the weather off it. The ladder broke.
Fell off the ladder and he got pronged.
Now then, it took me a long time till somebody finally told me what a prong was. It's a pitchfork. It is apparently quite common in some rural areas to refer to a pitchfork as a prong. So the pitchfork was leaning against the hedge, and unfortunately he fell off onto the pitchfork and died the next day. And the owner of the stack of peas and beans, he's probably perfectly happy to hand over the ladder and the prong, but he doesn't see any reason why the almoner should have the peas and beans. Were the peas and beans something that caused death?
Good question. No,
Yeah.
really. I mean, well, he wouldn't have been doing it had it not been for the peas and beans, but they were not the direct cause of death.
No. But, and he's certainly resisting. He's holding out, is the farmer. The currency is very, very difficult. I would say the almoner is going after about 15 quid. I would say. So there you go.
Forgive me, is this the only redress for £15 to go to your Majesty's Star Chamber? I mean, the Privy Council?
Yes, quite. I think the chance that it ever appeared in court is remote. I don't actually think that many of these made it into court. What is happening here is that for the almoner, it is very, very easy for him to instruct his clerk to just get some subpoenas done from Star Chamber, scare them, harass them.
And the cost of going down to London, would it be? The cost of going down and putting yourself up and keeping yourself in London would be enormous.
Well, the inconvenience of it too. You could do it without going down, because you would hire an attorney, a lawyer, but of course that would cost. That would cost too. So for the Almoner, it was a very clean and efficient way of putting pressure on people. But I've no doubt that this case came to some sort of settlement. I always think of Deardand as a sort of early health and safety fine. If your ladder had a weak rung, then it's possible it would kill someone and you would be in trouble. Not for having negligent, because there was no concept of negligence at this time in law. It was trespass on the case, I think it was called. But there was no, but the thing was that if what you had was faulty, then you could be in trouble with Deardand.
Would that be corporate manslaughter type of thing?
Yeah, that, once again, that just doesn't exist. I mean, it barely exists in English law now, I think. But it certainly didn't exist then. I mean, manslaughter was very iffy. You know, what was it? Was it murder if you didn't intend, you know, if it was an accident? What do you charge someone with? I mean, law changes all the time, and I certainly am not an Elizabethan jurist. And Elizabethan jurists argue like mad about, but they mainly argued about jurisdiction, who had the rights to the fees. You were going to ask something, Rachel? Did I see you? No. Any more? Or shall we go on to the next? Let's head for the next. What do we got? We have got the Queen's Almoner and Robert Bower.
To the Queen's most excellent Majesty, humbly complaining, showeth unto your Highness, your Majesty's humble and obedient subject, Richard, by the province of good Bishop of Worcester, your Majesty's high almoner, that whereas one John Duke, late of Wilford, in the county of Wiltshire, about 2 years past, driving a certain cart laden with wheat and 4 or 5 horses drawing the same, one of the wheels of the same cart went over the neck of the said John Duke, whereby he presently died, by reason whereof the said cart, wheat, and horses, with all their furniture to them then belonging, being all moved to the death of the said Duke, are forfeited to your Majesty as a deodand belonging to your Majesty's prerogative royal, and ought to be at the disposition of your Majesty's said almoner by force and virtue of your Highness gracious letters, patents,
Doesn't matter.
patents unto your said subject and almoner granted and made, as by the same letters, patents, more at large may appear. So it is, if it may please your Majesty, that one Robert Bower, a citizen of the city of New Sarum in the said county of Wiltshire, upon report made of the death of the said Duke, came to the party that was owner of the said cart, horses, furniture, and corn, and took, drived, and carried them away. By what authority your Majesty said almoner knoweth not, and ever since hath detained and kept them from your Majesty said almoner, to whom the right of the said cart, horses, furniture, and corn appertaineth, by virtue of whom the right of the said cart, horses, just reread that, by virtue of your Highness letters patent, by virtue of your Highness letters patents, as aforesaid, and refuseth still to deliver the same, or the value of them, being 20 marks of thereabouts, to your Majesty's said almoner, contrary to reason, equity, and conscience. in consideration whereof, and for as much as the said Robert Bower withholdeth the foresaid cart, horses, furniture, and corn contrary to law, equity, and right, obstinately and willfully refuses to yield and deliver to your majesty said almoner the value of them, the which tendeth greatly to the evil example of such like offenders. If condign punishment were not had and provided in that behalf. May it therefore please your most excellent majesty, the premises considered, to grant your most excellent right of subpoena out of your majesty's high court of Star Chamber to be directed to the said Robert Bower, commanding him by virtue thereof personally to be and appear before the lords of your majesty's most honorable privy council at a certain day and under a certain pain, by your majesty to be limited, and appointed then and there to answer all and every the premises. And your majesty's humble and obedient subject and almoner will daily pray to God for your majesty's most royal person long to reign and rule over us.
Thank you. You can see that despite the fact that we've got a number of different almoners, a number of different bishops, the wording is remarkably similar. I imagine that it's the same clerk or the same lawyer, but just working for a different bishop. It's very, very formulaic. But I mean, what's happened here? I imagine that the owner of the cart has employed somebody to take the cart, the horses, the corn, the harness, everything, just make it go away. And he claims he hasn't got it, it was stolen. But it's quite a sizable chunk. The almoner isn't claiming the wheel of the cart. It's not only the wheel, it's the cart. And it isn't only the cart, it's the contents. Lynsey.
Yeah, it's a very interesting detail that how the cartwheel went over the neck of John Duke. It's hard to imagine how that could have been accidental. I mean, how do you accidentally drive a cart over somebody's neck?
It is, if you've got an archery accident, it's pretty normal that at least one of the people concerned are drunk. And quite often asleep when hit. If you've got a cart and say a couple of people, a driver and what I believe is known in America as shotgun, if the road is bad or if a brake needs to be put on or something drops off the cart, somebody gets off, slips, falls, the cart moves. I can see it happening. Tom, you're with us twice.
I disappeared.
No, you're here twice, as far as I can tell.
I know.
By location. This is a miracle, a miracle.
It's which one is Jekyll?
I don't know. I don't know. This is exciting. Yeah, I mean, we don't have so many details, but it certainly, there's no suggestion here that it's anything but an accident. But what's interesting is that there are 4 or 5 horses. I don't know what that's about. I mean, nobody seems to know. And but he's claiming, he's being greedy to an extent in that he doesn't only want the cart, he wants the cart and its contents. I can understand the horses, they were providing the motion of the cart. but you've got quite an yes, you've disappeared. Tom keeps coming and going. Never mind. I mean, deer dams are far, far less common than the suicides. That isn't to say that accidental death was less common than suicide. It's just that for some reason, he has more difficulty in catching up with the suicides, because if there is a suicide, the local jurors are going to be as friendly as possible. Often they will find something is not suicide, is accident, when in fact it was a suicide. And you do get whole juries being brought to the Star Chamber by the almoner. I haven't got an example of one, but you do get them saying they deliberately did not bring in a verdict of suicide when it obviously was, because they were trying to protect the family. But that's more or less how Deerdand works. And that's more or less the end. I have just got one last little bit, which is from Middlesex. There was a barge. On it was Thomas Chattersley from Henley upon Thames in County Oxford, a bargeman. And he was on a barge called the Curry, which was laden with corn, wood, and meal upon the River Thames against Lambeth, nigh unto Westminster, Middlesex. And by misfortune, he was drowned. And the almoner is claiming the entire barge and its whole cargo of corn, wood, and meal. Now, obviously, by the time the almoner has got to it, it's arrived in London and been to market and sold and gone, and the barge is probably back in Oxford or wherever it's come from. But he's after the value of the barge and its cargo. And it, okay, I know in theory it's all going to charity, but I dare say there are fees that are deducted by the bishop en route. And it does certainly seem a touch greedy to claim the whole amount. But there we go. Now, has this been in any way useful to you in your in looking at the early modern world? No. Okay, it was unfair. How can you say no and still look me in the face?
I think it's interesting. I mean, there's nothing in these that jump out as being parallels to any work plays that we've dealt with over the last God knows how many months. But it's interesting to see the world in which those playwrights were writing, what they were encountering possibly or hearing on the streets. You know, there's a very good chance the playwright would have heard about a case, and even if it doesn't get reflected directly in a play, it sort of works its way into their psyche, if that makes sense.
There is a case, Giles Allen against a guy called Cuthbert Burbage, riotously dismantling a theatre. Yeah, it's them. And that I'm trying to get I'm sure I don't have to transcribe that, because it must have been transcribed by I don't know how many bidolaters. So I'm going to get hold of that, and we will certainly read that one. And there are others which have parallels, but no, I mean, the only thing here which was of interest was that the Countess of Northumberland married her steward. Quite. Yes. Okay, I seem to have stunned you into silence. Rachel, thank you. Say something.
No, I was gonna say, no, it is helpful. I mean, like, to get into the psychology of the characters in the plays that we do, the amount of, you've said before just how litigious people were back then, but the amount and the stakes of what you could lose is so high. And the way that you were saying, people were getting greedy in some cases. The idea of, I'm sure people had some idea of like unfairness, or maybe not all of them, but I'm sure some people, thought there's something wrong with this system. It makes sense the way people view suicide or talk about suicide in some of these plays, every once in a while that it comes up, in the way that they do, knowing that it really would adversely affect a family, affect a family economically, if it were to happen. That it's a felony, that it could bring not just the persecution, but that it's treated as some form of treason or felony.
Well, it's felony. It's a serious crime.
Yeah, that might harm somebody's reputation slightly, or family's reputation, even if it might
more than slightly. It was Tom.
Well, just following on. I mean, people were wedded to the land and the place, and they couldn't, and destitution. I mean, it was a cold, miserable, hard life if you didn't have your income stream, and people, as I say, were wedded to the place and what they were born into, and they couldn't swap income streams around. You couldn't suddenly. The only thing is that you were destitute, and that led to a very hard and short life, most probably.
I think so.
Yeah.
Lynsey.
I mean, I think I don't know about directly informing some of the early modern plays that we've been reading, but certainly just from a general interest point of view, I didn't know this about suicides. I didn't know that this was the legal situation with their goods. And I'd never heard of a diadem. Is that the right word?
Diadem, yes.
Yeah, I'd never heard of this before. Of this,
abolished 1846.
Extraordinary. I'd never heard of it before, and I can't think of an instance in a drama where it's applied. But what's interesting is that when you don't know something, you don't pick up on it, and so who's to say that there won't be texts in the future whereby there'll be some little reference to something or whatever, and you suddenly go, oh, they're referring to diadem, or they're referring to this, felon de se or fella de se law, which just because I didn't know it existed. I didn't pick up on it. So I think it's very interesting stuff, actually, even though it's not really drama, obviously, but it's just very interesting, I think.
Somebody was, in a completely different context, somebody was saying, I can't understand this man. He's killed somebody, and all people are worrying about was how much the sword was worth. And I was saying, dear Dan, killed somebody, sword has value, belongs, oh, you know, dear Dan. But it's it's there, but it's all underground. Are we done? Yep, we're done. Well, all that remains then is for me to thank these wonderful readers from the Beyond Shakespeare Company, and to say to you, is your our bounden duty, we shall daily pray for the Queen.